Public International Law, PIL, Unit 1. So these are the important questions in PIL. We will see one by one. The first question is definition of international law. The question will come as critically examine the definition of international law. So you will have to write at least 7 to 8 definitions. The definitions, all of them are usually same. One thing is same. They all say that international law is a body of rules. But the only difference in all of the 7 definitions is that they said that to what it applies. The international law to what is applied, to what it applies. Some say that it only applies to states. Some says that it just does not apply to states but also applies to individuals and international organizations. So we will see all the definitions one by one. Oppenheim. So what Oppenheim says that international law is a body of rules which is only applicable to civilized states. So Oppenheim clearly states that it is only applicable to civilized states. It is not applicable to anyone else. So criticism to his definition is that public international law is also applicable to international organizations and individuals also have rights in international law. So he is telling only that it only applies to civilized states is wrong. The next is Soviet definition. What Soviet says is that international law are norms which are developed as an agreement between states and it expresses the will of a ruling party and it is enforced at the time of necessity. The next is Chinese definition. So what Chinese says is that international law is developed as a creation of state, is related to creation of state and it automatically gets developed when states are created. So this is Chinese definition. The next is Kelson's definition. What Kelson says is that international law is a body of rules to regulate conduct of state in their intercourse. So intercourse means the flow of goods or trading. So it's a body of rules to regulate states trading, Kelson says. The next definition is of Charles G. Fenwick. So what Charles G. Fenwick says is that international law is a body of general principles and specific rules which is binding on members of international communities. He does not include the term states, he includes the term members of international community, which is a broad term and it can include states, individuals and international organizations, etc. The next definition is of Whiteman. So what Whiteman says is that international law is a standard of conduct at any given time for states and other entities subject thereto. So what Whiteman says is that it is applicable to states as well as other entities which are a subject of international law. The next definition is of J.G. Stark. So what J.G. Stark says is that he gives a detailed explanation of international law in his definition. So he says that it is a body of law which is applicable to states first. Then he continues his definition saying it also includes international institutions and organizations and it also includes individuals and non-state entities. So he gave a broader definition to international law and it is the most important definition. The next is cases. In case S.S. Luthor's case, international law was defined as it is a relation between independent states out of their own free will. So states that doesn't have will in this, they have to obey international law as a relation if they want to have relation between states. In S.S. Luthor's case, it was held. So this is the first question. Nature of international law, or is international law a true law? We will discuss in this question. It has been asked for 10 marks repeatedly. So the answer, in 1884, jurist Lawrence remarked that it depends upon the definition we choose. So it depends upon the definition we choose. There are two definitions basically. One is Austin's definition and the other is Oppenheim's view. So there are two views to international law. One is Austin's view and the other is Oppenheim's view. So in brief, Austin says that international law is not a true law and Oppenheim says that international law is a true law. So we will see in detail what they say. So what Austin says is that his theory is law is the command of sovereign and it is enforced by superior political authority. Arguments. He says that municipal law has a superior authority which regulates it. but international law does not have any superior authority. His next argument is that international law lacks a legislative machinery. There is no legislation in international law, and international law lacks sanction, essential element of law. So, what are sanctions? Sanctions are punishment imposed when the law is not obeyed. So, in municipal law, state law, if you don't follow any law of the state, then you will be punished. There will be sanctions for it. But in international law, there are no sanctions. It lacks sanctions. The next is no executive power to enforce international laws and treaties. So, even if they create international laws and treaties, there is no external power or executive power to enforce it in international law. International law lacks a potent judiciary. There is no good judiciary, and some writers call it Kslu law. Oppenheim's view. So, what is Oppenheim's view? Oppenheim says that Austin's definition does not cover unwritten municipal law. So, what Oppenheim argues is that there are states which have unwritten constitution. They have unwritten constitution, and yet they are sovereign, and they have laws, and it is called as a law. Their law is called as a law. So, this is Oppenheim's argument. So, law definition. Oppenheim gave a definition for law. He says that it is a body of rules for human conduct with common consent enforced by external power. So, different law is that it is a body of rules for human conduct, and humans should have given consent for it. And if humans doesn't obey it, then it can be enforced by external power. Pollock says that for essential conditions for law is a political community only. So what Pollock argues that if there is a political community, then it is an essential condition for law. So essential conditions for law in detail: there should be a community, there should be a body of rules, the common consent of community, and enforced by external power if necessary. So you have to raise these two views. The next concept in public international law first unit is sources of international law. So Article 38 of International Court of Justice has given 5 sources in total. The first is international conventions, then lawmaking treaties, treaty contracts, international customs, general principles of law recognized by civilized nations, and decisions of judicial or arbitral tribunals and juristic works, and decisions or determinations of organs of international institutions. So we will see one by one. The first is international convention. So it is nothing but international treaties, and Article 2 of the Vienna Convention on Law of Treaties 1969 defines treaties as it is an agreement between two or more nations which governs the relationship, and it is governed by law. And the next definition is given by Professor Schwarzenberger. He says that it is agreement between subjects of international law, creating binding obligations in international law. So he says that it is an agreement between the subjects of international law between states, and it creates a binding obligation once it is created. So that is a treaty. There are two types of treaties: lawmaking treaty and treaty contracts. So in lawmaking treaty, what happens is it is created general in common to all the states. All the states are a member of party of this treaty, and it is applicable to all the states in general, and it acts as a source of law. The next is treaty contracts. Treaty contracts is only applicable to two or more states. Only two or more states, for their convenience, they enter into a treaty, and it is applicable only to those states, and it is only binding on the parties of the contract. The next is international customs. So what is international custom? It is an usage that has obtained a force of law. It is a usage among states. States are following certain usage, and because they are following it for a long time, it gains a force of law, and once it obtains a force of law, it is called custom. Elements of a custom, valid custom: it should be of long duration. It should have uniformity and consistency. It should be generally practiced by everyone, and opinion juries at necessities. It should be a requirement of international law. It should be required by an international law. Only if it is a requirement of international law, it is a source. It is called custom. There is a case law, West and Central Gold Mining Company Limited versus R. So what in this case it was held that if there are satisfactory evidence for a valid custom, there should be a satisfactory evidence that it is working for a long time, and it should have received consent of all of the nations, and no civilized nation should oppose this custom. Only then it will gain the force of law. The next is general principles of law recognized by civilized states. So what it means is that these are the rules and standards which are necessary for human association. They are need of human. So what are the general principles? Good faith, responsibility, prescription, res judicata, fair trial, etc. The next is decisions of judicial or arbitral tribunals and juristic works. So what are these? These are the international judicial. There are international judicial decisions. These are court decisions. In this, the first is international judicial decisions. The decision given by ICJ, International Court of Justice, acts as a source of law. The next is state judicial decisions. The decisions given by states in their own countries acts as a precedent to the source. And the next is the decisions of International Arbitral Tribunal and juristic works. So juristic work means the famous personalities who are experts in juristic works. If they give certain thing, then it may be taken as a source. The next source is decisions of and or determinations or organs of in international institutions. So what are these international institutions? UN. Whatever these international institutions give certain order, then it acts as a source of law. The first is United Nations, and the next is for food, FAO, Food and Agricultural Organization, and they for health we have WHO, World Health Organization, and for laborers we have ILO, International Labour Organization, and for relation between states we have ICAO, International Civil Aviation Organization. So these organizations, whatever command they give, whatever rules they make, it acts as a source of law.